Good morning. Welcome to your North Carolina Court of Appeals. My name is Chris Still, and I'll be presiding today. To my right is Judge Don Stroud. To my left is Judge Bud Gore. I thank Officer Salou for being here. He's our marshal today. And we have our clerk, Gene Soar, here. Thank you for being here. We have one case on the calendar, the State of North Carolina versus William Barthel. So if the appellant is ready, you may proceed. And I want to go ahead and ask, you'll have 30 minutes aside. I think there might be a confusion in the calendar, but you will have 30 minutes aside. So just want to let y'all know that. So we're sorry for any confusion. So we'll err on that side.
Sir, thank you, Your Honor. Thank you, Chief Judge Dillon, and may it please the Court. My name is Brandon Mays, and I represent Mr. Barthel. Your Honors, at a basic level, Mr. Barthel had the constitutionally protected right to display the message on his banner in silence in the back of the boardroom. Under First Amendment precedent, it is axiomatic that the government cannot prohibit speech based on the content of the message conveyed. And there is an unmistakable significance in protesting as close as possible to the seat of government, which is of undoubted significance in the constitutional balance. Thus, Mr. Barthel had a right to express his views about a county employee without engaging in disruptive conduct before the county board. Watson's restriction in an unlimited forum was content-based and viewpoint-based and does not survive strict scrutiny. Watson could not prohibit Mr. Barthel's message based on his content because the board meeting was an unlimited forum. The Supreme Court in Cornelius says that we don't commonly classify any fora. Instead, we look to the individual circumstances of the forum. Those include the government's express intent when creating the forum, the historical uses of the forum, its compatibility with free expression, and any restrictions that the government may place in creating the forum. If you do the Cornelius analysis here, the meeting was a designated public forum. That is, a forum open for a limited time, but without restrictions on who can attend, and without limiting public comment to particular topics. Starting with the government's express intent in creating this forum, we look to our general statutes on public meetings. NC Gen Stat 143-318.10 makes all official meetings of government bodies open to the general public without restriction. And Section 153A 52.1, which governs public comment periods, does not place a limit on public comment to particular topics. Looking at the board's rules, written in accordance with the public meetings laws, the rules do not restrict who can attend or limit speakers to certain topics. In fact, the board's own rules acknowledge that non-agenda topics will be raised during public comment. If you look at the record on page 33, subsection M of the rules, it states that no action shall be required by the board on any non-agenda items raised during public comment period.
Let me ask you a question. So let's say this is a council and it's your turn to talk. If the defendant was in the back of the council meeting and was yelling these words, would that be different because it's disruptive?
Absolutely, Your Honor. I think under that analysis, his disruptive nature removes the
Would any conduct that distracts the speaker whose turn it is to speak be a fair game for the sake of the council to regulate? And why wouldn't a sign with this provocative statement be distracted of the person whose turn it is to speak?
Because the sign is merely words, and as Cohen
So if he's talking the words, if he's yelling from the back, those are just words.
well, he's taking up literally space and volume in the meeting, and the board has
So there's a difference between if he was speaking or he's just holding the sign. You think there's a difference?
There is a difference, yes, Your Honor, and Cohen says that a simple display without conduct attached to it. So in your example, yelling in the back of the room, the board could remove him or ask him to leave, and that would be a valid time, place, and manner restriction because he's speaking over someone. Two, in the manner in which he's speaking, he's loud, he's interrupting, and he is actually disrupting the conduct of the meeting.
What if it was a bright neon sign that says words? Would that be disruptive?
Your Honor,
I guess where do you draw the line on what's disruptive and what's not?
well, I think when we're talking about just speech, as Cohen says, we can't just draw the line. The conduct,
Well, we are if he speaks, but I mean, if
Absolutely.
he yells, I mean, that's a line. We have to draw it somewhere, or it has to be drawn somewhere.
I guess, Counsel, the question to piggyback on is the arbitrary part of Cohen, is that where the line is Is that what you would say the line is? They seem to use the term arbitrary in code. Is that where the line is?
Right, and we're talking about just words, and, whether it's words on a banner, a shirt, a neon sign, which it's hard to, it's a good question because it's hard to draw the line around that. But at least we have, in this case, words on a sign. And Cohen says, look, when we're talking about just words, the government doesn't have the tools to objectively distinguish here. And so we shouldn't let them. And, here in a designated public forum, which this meeting was, strict scrutiny applies to content-based restrictions.
Well, let me ask you, speaking of Cohen, so Cohen said that the display of the four-letter word was clearly not directed to the person of the hearer, and no individual actually likely to be present could reasonably regarded the words on his jacket as a direct personal insult. So here we have a banner that's specifically targeting one of the board members.
Correct.
So isn't that, how does Cohen support that, since this is something that's specifically targeting one of the board members?
So Cohen, in that instance, is discussing whether Cohen's words amounted to fighting words under the fighting words doctrine. Cohen is one of the examples since Chaplinsky where the court has basically run away from the fighting words doctrine without overturning it. And I would say, just as fighting words go, pretty simply, if burning a flag and burning the American flag in public, as in Texas v. Johnson, telling someone, you white son of a bitch, I'll kill you, as in Gooding, yelling MFing cops at police officers in Lewis v. New Orleans, bringing a cross in someone's yard, as in RAV, a litany of offensive language displayed at a dead Marine's funeral in Snyder v. Phelps aren't fighting words, then the words on Mr. Barthel's banner weren't either. So, Your Honors, as a designated public forum, any content-based restriction is subject to strict scrutiny. Here, a content-based restriction, as clarified by the Supreme Court in Reed, prohibits speech based on its subject matter or topic. The relevant restriction here was Watson asking Mr. Barthel to remove the banner. And Watson testified pretty plainly that it was because of the content. In the transcript at page 20, he testified that he asked Mr. Barthel to take the banner down because of, quote, what was written on the banner. This is the very definition of a content-based discrimination under Reed. And the state's argument in its brief that, well, Watson really meant the manner in which he expressed his views just doesn't make sense. You have to fundamentally change Watson's testimony to what was written on the banner, from what was written on the banner to because it was a banner. But he didn't say that. Thus,
Could they have had a rule? What if somebody else had another banner that said "God bless America"? Could they just say, we're not going to allow any banners? Could they do that? Would that have been okay?
the rules actually state that. I think as that would get into intermediate scrutiny as a time, place, manner restriction
The rules
because
state what? No banners?
yeah, but as a
So he was violating a rule.
but
So do we care about the officer's subjective intent, or do we just look at it objectively? He was breaking the rule.
no, he's well
If he's breaking the rule, why can he say, you got to take that banner down, whatever?
because we don't know if Mr. Barthel had a banner that said, you know, Cindy Turbofill is a great person and great county employee. He stated, this is why I did it, not because he had a banner. And the state's argument makes you change his testimony to because he had a banner.
So you're saying the officer's subjective intent of enforcing a rule is relevant?
Once it's stated on the record, it is. You know, he could have said he's violating the rules. I'm kicking out, and then it's content neutral.
Because I thought like, well, I mean, it's a different thing, because I know if the police stops you, it doesn't matter what the subjective intent is, because if it's objectively reasonable, then it's okay to stop.
Yes, Your Honor. That's
So wasn't it objectively reasonable, if it was objectively reasonable for this officer to arrest this person or whatever?
And the First Amendment, when we go and Reed clarifies sort of how you do this content-based analysis. In the past, you know, the courts had said, well, you can look to the government's content-neutral justifications, and that can get around this. Reed says, no, first we look to, and Reed was dealing with actual, the facial
But he's not
validity of the law.
charged with what he said. Well, he's charged with resisting arrest, so do we look at, did the officer have an
And
objectively
disrupting.
reasonable?
And disrupting.
And disruptive.
So he was charged with disrupting a public meeting and resisting arrest. But my point is that Reed says you look at the law, in this case, the reason for the restriction on its face, then you can get into government's content-neutral reasons for implementing a law. But here, Mr. Watson said it is because of what was written on the banner, the content of the message. And as a content restriction, the state needs to show that the restriction was narrowly tailored to achieve a compelling government interest. Here, the state correctly acknowledges that the board had just a substantial interest in maintaining decorum in its meeting. Also, even if it had a compelling interest, the restriction wasn't narrowly tailored. Reed says that a restriction can be hopelessly under-inclusive such that it undermines the interest that it's meant to serve. In essence, it prohibits some speech directed at its goal, but it allows other speech that can create the same problem. And here again, look at the board's rules that restrict rule subsection J on page 33. It says speakers shall refrain from personal attacks, however personal attacks is defined, but take it to mean any negative opinion expressed about anyone at the meeting. The rules do not mention at all any personal praise or positive opinion of someone during the public comment period. And by not addressing positive opinion, it allows the same problem that someone is interjecting something that isn't germane to the agenda at the meeting. So because the content restriction here didn't serve a compelling interest, and even if it did, wasn't narrowly tailored, it failed strict scrutiny and violated Mr. Barthel's free speech rights.
I guess, Counsel, and let's see, I don't disagree with your characterization of how the rule reads, but is there a delineation whenever it starts off with speaker versus present, maybe, in the analysis? Because in this instance, there is a distinction.
I think, Your Honor, the rules are set up for someone who is signed up, go take the podium and speak to you just like I am right now.
At the podium.
But I think, and that's sort of what the board expects, and I think what we all expect. But I think there is like I said before, at a basic level, Mr. Barthel has the right to come into the board meeting while not otherwise engaged in disruptive conduct and sit there with the banner with a message on it.
So is it the argument that, in essence, this really shouldn't even apply to him because he wasn't at that time speaker?
I think it helps sort of delineate.
And that's to address the question that Judge Dillon asked about, well, was he complying with the rules or not of a banner? But in this instance, he wasn't a speaker, so does this rule apply to what he was actually doing?
I think you could read it that way. I think even if it does apply to him, under our bedrock First Amendment principles, he had the right to go into the board meeting room without disrupting anyone, without putting the banner between between the public and the board, sit back there with a simple display as in going, and put his message out there. In Johnson, the court says, if there is a bedrock principle underlying the First Amendment, it's that the government may not prohibit the expression of an idea simply because society finds it offensive. Cohen goes on to say it's one of the prerogatives of American citizenship. It's the right to criticize public officials and measures. And that means not only in a sort of informed and responsible way, but to speak foolishly and without moderation. And then to do that as close as you can to the seat of government. So I think the alternative is, say he wasn't in the back of the room with a banner. If he had signed up and gone up to the podium and said what he had to say to the board, that would have been more disruptive and counter to the board interest in maintaining decorum, although under our precedent, still constitutionally protected, but it would have been more disruptive. Him sitting at the back of the room with the banner up was less disruptive than other alternatives he could have used in that forum.
Let me ask you a question. I'm not talking about the disruptive charge. Is it constitutional for a council to have a rule, no banners allowed?
Your Honor, I think under a time, place, manner analysis, then the government has to show a substantial interest, which I think we agree it has here, but narrow tailoring still applies. And I think that no banners and no flags is over-inclusive in that it restricts basically all speech in that form. But it does.
This rule is unconstitutional, whatever the rule they have in place, no banners.
I think you could argue that, yes, Your Honor. It's not sort of central to this case, but I think
it's not unconstitutional. Did this officer have the right, within because as I read the facts, it says you need to take that banner down. I mean, whatever subjective intent was, and when the defendant didn't take the banner down, did he have the right? Why isn't the resisting charge at least okay? I'm not talking about the disruptive charge, because that would be what it said. I'm just talking about just the rule. You can't have a banner. This officer just simply enforcing the rule and says you need to take that down. When the defendant didn't do it, why isn't that enough to sustain a resisting a public officer charge?
I think in the context of this case, because Mr. Barthel had a right to go in there and with a banner and say
you're
this
saying
message, as a basic point.
So you're saying the banner rule is unconstitutional? That's what I'm trying to
Yes, Your Honor. I think it's unconstitutional. I think it would sweep up too much speech. It's not narrowly tailored to the interest in that. It leaves, it just totally does away with banners and flags when they may not even be, sort of disruptive.
Go ahead.
I mean, he also had on an offensive T-shirt. I mean, how do we separate banners, flags, and T-shirts? I mean, a T-shirt's just a flag or a banner you're wearing.
Right, and that's the same case as in Cohen.
Yeah.
The government can't sort of restrict that. It's just a simple display without otherwise disruptive conduct. So yeah, I think because
They could say no neon signs. No, I don't care what the message. Don't hold up a neon sign. We're not going to allow that.
Well,
So you're saying you cannot have a rule you cannot have a rule at a city council meeting. No, we're not going to allow any banners in here. I don't care what it says. It's totally content neutral. I mean, if they can, then I'm having a trouble with. If they can have that rule, then why couldn't at least the resisting charge stand? Because this officer would have the right to say, you need to take that down. And when he said, no, I'm not going to do it, that's sort of resisting.
So I don't think they
Assuming
can.
that's okay to have that rule, content neutral.
I don't think it's okay to have
A content neutral rule, no banners.
no banners. I think you could have a rule.
That's what I'm trying to
I think you could have a rule that's more narrowly tailored that says no banners that obstruct the board from the public. That kind of rule would be fine and narrowly tailored. An absolute ban on banners is overbroad, in my opinion.
now, he was standing in the back of the room, as I recall.
Yes.
So he wasn't blocking view of anyone.
No, Your Honor. In fact, Deputy Hicks, who was sitting right in front of him, had no idea anything was going on until Watson came to tell him to take it down.
So different if he were standing on the front row, maybe, and blocking the view of the people in the audience.
I think so. Then you have conduct that is disruptive, that gets between, the board and the public, and that's a different case. But I just want to make sure, Judge Dillon, that I fully answered your question. I think a total restriction on banners is not okay. I think Watson's subjective intent in telling him to take the banner down matters. And then getting to the resisting, all of that flows from the moment Watson told him to take the banner down. Once he's doing that, he's violating his constitutional rights. And under our precedent, Mr. Barthel has the right to resist proportionally, staying in the same place as someone who's exercising the right of self-defense. If there are no more questions, I'll reserve the remainder of my time for rebuttal.
Thank you.
Thank you, Your Honor.
From the state. Let's go to the clock right. Okay.
Good morning, Your Honors, and may I please support. My name is Nick Brode. I'm in the Department of Justice, appearing on behalf of the state. The Avery County Board of Commissioners convened a public meeting, solemnized the event with the pledge and a prayer, and warned gathered that if they disrupted the meeting, they'd be asked to leave. The defendant here then unfurled a profane banner, refused to leave the meeting, and resisted officers when they tried to restore order. If the defendant had unfurled the banner on a public street, there's no doubt that the First Amendment would have fully protected that speech. The different question here is whether the defendant also had a First Amendment right to unfurl this banner in a public meeting while the meeting was underway. The answer to that question is no. The First Amendment doesn't prevent the government from seeking to ensure that public meetings are civil and orderly. A public meeting is a specific location that the government opens up to conduct government business and allow for citizen input. That means it's a limited public forum under the First Amendment where the government can enact speech regulations so long.
No, wasn't his banner public input that one of the officials, I mean, if he had had a banner or a sign or had on a shirt, and he said, this person is incompetent and should be removed, wouldn't that be an appropriate topic for, I mean, whatever the basis of his opinion, but that's something that would be, certainly a citizen would be able to say in a more polite manner, but why can't he say it in a rude and offensive manner?
He can't say it in a rude, offensive manner because this is a limited public forum. In a limited public forum, the government can reasonably decide that allowing individuals to speak using profane language or launch personal attacks would undermine the civility and orderliness and decorum.
But isn't that a content? I mean, all of these cases, dealing with these speech cases, they're all things that are just very offensive, right? I mean, we don't have any cases about people saying, have a nice day.
That's true, Your Honor. I think the fact that this is a limited public forum is essential to my analysis. In a limited public forum, you're only asking two questions. Is the restriction viewpoint-based, and is the restriction unreasonable? So you can't discriminate based on content in a limited public forum. That's sort of the whole point of a limited public forum.
But doesn't that normally really just kind of guide the government's restrictive ability on verbal speech? Because I can't see a real case on point on the signage arguments. I'm not disagreeing with your analysis on the verbal or vernacular argument, but getting to that same analysis and how it applies to signage.
Your Honor, I don't think the parties cited you a case about signs. I do think, Chief Judge Dillon's earlier questions, that a local government could pass a rule consistent with First Amendment that just categorically bans signs, banners, and flags. And in fact, as I understood my opposing counsel to concede, there is such a policy here. It's at record page 33, and the defendant was in violation of that policy. And I think the reason that a local government could say we are getting out of the sign business, the banner business, is because once you let in one sign, you have to let in all of them.
But but doesn't that application have to be narrowly tailored to the reason and basis of what they're trying to do?
Your Honor, I don't think there has to be narrow tailoring here because we are in a limited public forum. And because we're in a limited public forum, I think the only thing that the government policy has to be is viewpoint neutral and reasonable. And I do think it is reasonable for a local government to conclude that if you were to permit anyone to come into a public meeting with signs or banners, that would be highly disruptive of the meeting.
So would that mean they could also say, because he had on, like I said, he had on an offensive shirt also.
Yeah.
So they say no writing on shirts. Can you say no hats with any writing on them?
I don't think a government can go that far. So I do think there is a constitutionally significant difference between a sign, a banner, a flag, and a personal effect like a shirt or a hat or a button. I think a local government could enact some sort of policy that says no profanity on shirts in order to preserve the decorum of the meeting.
So you could have let's say he said that had the very same thing that was on his banner on his shirt.
I think a local government could say, no, this is a public meeting. This is a place where we're going to be civil and respectful and maintain order. And using profanity and a personal attack on a shirt is inherently disruptive and not the type of speech that's permitted in this type of forum.
How is it inherently disruptive?
Your Honor, I think it's inherently disruptive for some of the reasons that the Fourth Circuit explained in its Steinberg decision, and I think this is the best case for my position, and I would commend Steinberg to the court. Steinberg talks about the risk of a limited public forum like this sort of devolving. Once you have one personal attack, a response can follow, other people can chime in, and the meeting stops being about the important topics that are there to be discussed, and it starts becoming about something entirely different, which is the manner in which this one person has chosen to speak. I mean, I think it's not dissimilar.
I want to make sure I'm processing the analysis and answering what Stein's on verbal speech attitude, right?
You're right. That's correct. That's correct. And as I said, I don't think the parties have cited the court case specifically about signs, and I appreciate that there may be a difference between verbal speech and signs. I think my argument is that in light of the Fourth Circuit decision in Steinberg, it is a reasonable thing for a local government to say, we want to have orderly, efficient government meetings, and so we are going to categorically prevent things like signs, profanity, or personal attacks in this unique space so that the meeting doesn't go off the rails.
Well, I guess the problem is what one person considers offensive, another person might not. You know, I could have a shirt that says Jesus is Lord. That might be offensive to someone of another religion. So I can't wear that?
Your Honor, I think a ban on offensive speech would probably be viewpoint-based. That's not the policy that's at issue here. This is a ban on 1, profanity, 2, a personal attack, and 3, a banner. And so I don't think that it requires that kind of subjective judgment call in the way that a ban on offensive speech would.
Well, how do we define even what is profanity? There are a lot of words that people use today, like all the time, and some people use them as nouns, verbs, adverbs, adjectives. Who knew that one word could do so many things? But, you know, that we used to think was not a word that you would use in polite conversation.
Your Honor, I appreciate the fact that there may be some difficult edge cases about what constitutes profanity. I do think there's sort of a core set of words that all of us speakers of the English language understand to be profane words. And certainly the facts of this case here, I mean, there's no dispute that this constitutes profanity. The way that I would think about a ban on profanity is it's sort of like a ban on loud speech. So the policy that the court analyzed in its recent decision in Barber, it's about the manner in which you are choosing to express an idea, not what you are saying or the viewpoint of the message that you're attempting to convey.
But here he wasn't making any noise. I mean, he was in the back of the room. He was actually not making any noise at all until the officer went up to him. Is that right?
Your Honor, that's true. He was not making any noise. I concede that. I think that it is inherently disruptive to unfurl a banner in the middle of a public meeting. I mean, just to give you a concrete example, I think if someone were to unfurl a banner in the back of this courtroom while this oral argument was underway, I think the court would find that highly distracting, irrespective of the words that were on the banner, because...
Let's follow that vein of discussion.
Yeah.
Here, there's only two people that can sign up to get to the podium. In Hickory County, meeting, everybody that is there is free to sign up to get to the podium.
Yeah.
So if you really want to talk about limited, really limited here, not as limited there. So I guess my question in looking at that, if anyone that was in audience got up and stood up at that and didn't do anything, let's take the signage piece, let's take the purpose part of it. They stood up in the back. They would stand in the back the entire argument with no disruption. But if our bailiff, our marshal, went up and engaged him, at that point there could be a disruption. So get me to how him unfurling the banner is inherently disruptive without government involvement. Because it seems like when we literally break it down, it didn't become disruptive until there was government interference. Get me how his individual conduct is inherently disruptive, with nothing in the record that I've been able to see and flush out that provides facts of how disruptive, that's what's out, until there was government interference also.
Your Honor, I do think there is some evidence in the record about the manner in which this was disruptive. I mean, I think I would point you in particular to trial transcript page 67, where Officer Hicks talks about sitting in the meeting room and hearing the banner unfurl behind him. There's also some testimony in the record that the chairman of the County Board of Commissioners asked the defendant to leave multiple times because this was disruptive. But, I mean, I do think that unfurling a banner, irrespective of those pieces of record evidence, is inherently disruptive. I think for the reasons that I was trying to explain earlier about why it would be disruptive if someone were to unfurl a banner in this courtroom. It's visually distracting. It's visually disruptive to the members of the court when you're trying to focus on the arguments of counsel if someone were in the back of this room.
But, the people who are public officials, like this meeting, I mean, that's kind of part of the job. That obviously you're going to have people who are unhappy with what you're doing, and they're going to express themselves in various ways. I mean, that's just part of the job.
Your Honor, criticizing the government is what's at the core of what the First Amendment protects. I don't dispute that. I think the question here is not what the defendant said, it's where and how he said it. And there were lots of other channels that the defendant could have communicated this criticism. He could have signed up to speak at the meeting and conveyed his concerns about this individual to the county board. He could have, as I mentioned in my introductory remarks, unfurled a banner on a public street. Record here shows that the defendant has a number of social media accounts. He could have posted to social media about his concerns. There's lots of different channels in which an individual can relay criticism about government officials.
But he might think that the most direct way to do that and the best way to do that, since he's criticizing this particular public official, would be to do it in the public comment period of the meeting.
And, Your Honor,
does he have to limit himself to something online that that person is likely never going to see?
No, Your Honor, and he could have used the public comment period at this meeting to convey his concerns. All he had to do was sign up on a form, and he would have been offered an avenue, a set period of time to speak at the podium to the county commissioners and convey his concerns, so long as he did so in a civil and orderly fashion. And that's the problem with this case, is that the defendant was communicating those types of concerns in an uncivil manner that disrupted the meeting.
Counsel, you said that the fact that, I'm going to get back to the disruptive, the fact that he unfurled the ban was indirectly and was distracting, was determined
falls within your definition. Yeah. Your Honor, I do think there are some really important guardrails here that prevent abuse of this statute. I mean, one guardrail is, under the First Amendment, any government regulation has to be reasonable. And so if you have someone throwing someone out of a public meeting because they're having a coughing fit, I mean, that seems pretty unreasonable to me. The statute...
Does that fall within your definition of disruptive?
Well, so then let me turn to a second point, which is the statute itself. So the text of the state statute itself, I think, also has some important guardrails, which is that there has to be willful disruption. And in order to be convicted of this particular misdemeanor, you have to be informed that you need to leave the meeting and willfully refuse to leave. So there are some guardrails here that prevent sort of any conceivable disruption from being criminalized in a way that I think is very important. I think the other thing that I'll say is I don't think that you need to go as far as holding that any banner is inherently disruptive in order to resolve this case. I think there's a narrow way to resolve the case which focuses on sort of three key facts, which is one, the act of unfurling the banner, two, the fact that the banner has profanity on it, and three, the fact that the banner has a personal attack. And it's the combination of those three facts, I think, that is a narrow way to sufficiently resolve the case.
This is how I'm kind of seeing it. I mean, and I'm troubled by, I think if you have a, I mean, to me, this case turns on, is it constitutional for a council to have a rule that you just can't have a banner? Because it'd be problematic if he said, you got to take your banner down because you got offensive content. But since yours says, God bless America, I'm not going to enforce it here. That would be problematic to me. But I don't see any evidence that there was any discrimination. This was the only banner that was there. Right. And I'll allow you a chance to respond to this. And so does it matter what this officer's subjective belief was? He didn't express it. He just said, you need to take that banner down. And it is a rule. And when he didn't do it, that's what was disrupted, his act of not complying with the rule, not what was said, not the fact that he was attacking this woman, because that gets into the content. I'm trying to take the content out of it. Yeah. So does it matter what this officer subjectively believed when he enforced this rule?
No, I don't think so. I don't think his subjective intent matters because this is a First Amendment as-applied challenge to a state statute. This is not a civil case. It's not a case about retaliatory arrest or false arrest where perhaps under certain circumstances the officer's subjective intent could be relevant.
Again, I find it problematic that you're saying that we should consider that he was attacking this person. I don't want to get into the content. It's just you have a rule, no banners, and there was only one banner there, and he said, you got to take it down. I mean, irrespective. And he didn't say you got to take it down because it has vulgarity. He just says you need to take that down. He didn't do it. So to me, this case seems to turn on, is it constitutional to have this rule, no banners allowed in a public meeting?
And, Your Honor, I think that it is. I think that it is because that is a viewpoint-neutral rule, and it is reasonable in light of purposes of the forum.
Was there any evidence that other people had banners that were allowed to keep up ever?
No, Your Honor.
Okay.
So can you also say shirts and no hats and no pins and
Your Honor,
anything of that nature?
Your Honor, I do think there is a constitutionally significant difference between a sign or a banner and a personal effect like a shirt or a hat or a button. I don't think that it is reasonable for a local government to go that far. I think my argument depends on your accepting a line between things like banners, signs on the one hand, and buttons, shirts, personal effect.
I mean,
there is no rule about that, though. There's no rule.
That's right.
Well, if we're assuming, and like I said, I'm assuming the banner's in the back and it's not blocking a view or anything like that, why is there a difference between a banner and a shirt?
Your Honor, I think it's the act of unfurling the banner in the middle of the meeting.
Well, okay, what if he just walked in with he's already holding it?
I still think that's disruptive. It's a closer case. I would concede that point, but I still think that's
Because
disruptive.
it wasn't like loud. I mean, I've seen the video. It doesn't seem to be loud or anything.
It wasn't, and again, I mean, I don't want to fight Chief Judge Dillon's earlier point on this, but I do think there is a narrower way to resolve the case if you are concerned with the idea that unfurling a banner is inherently disruptive, which is that I think under the Fourth Circuit's decision in Steinberg, it is permissible, consistent with the First Amendment, to prohibit profanity and personal attacks, at least in this very unique context, which is a limited public forum where the government is attempting to conduct an orderly and efficient meeting.
So I guess answering that question, both of those questions, keep going back to the unfurling was the issue, but I guess in the analysis I gave you, the shuffling of the papers, because you clarified the rules. Shuffling the paper is personal. So before anybody
Let me give you two answers to that. So I think my top-line answer is the act of unfurling a banner in the middle of a public meeting that's ongoing is inherently disruptive. And if an individual is asked to leave after doing that and willfully refuses to leave, that is a violation of the misdemeanor provision, as you hear. But my backup argument is I don't think you have to go that far. I think on the facts of this case, you not only have a banner, but you have a banner, one, with profanity on it, and two, with the personal attack on it.
Okay, so,
Willfulness, I got one quick
go ahead.
So is your willfulness on the not leaving or the willfulness of displaying?
It's both, Your Honor. The statute says you have to willfully disrupt as well as willfully refuse to leave the meeting once you've been asked.
So the willfulness of shuffling papers could be applied the same way, right?
Your Honor, as I mentioned earlier, there's always a reasonableness check under the First Amendment. I think it would be very unreasonable for a local government official to seek to convict someone for a misdemeanor for shuffling papers in a public meeting. I think that'd be very unreasonable. I also think that individual would have to be told, you need to leave, and there would have to be evidence they willfully refused to leave.
But the unfurling of it itself, you don't know what's going to sign until it's completely open. So the act that you're speaking of is an act of doing something without knowing what the content is. And so you're applying willfulness to something that you don't know what the content is.
Yes, Your Honor, and I think that's a good thing for me under the First Amendment. The act of unfurling a banner, regardless of what it says, is inherently disruptive. That's why there's a rule on record page 33 that the Avery County Board of Commissioners has adopted that says no banners in this particular location. And that's a viewpoint-neutral line that a local government, I think, is within its authority to draw. But as I said, I don't think you need to go that far in order to resolve the case. I do think there's additional facts that support my argument here, which is the profanity and the personal attack. And for that point, I would direct the court to the Fourth Circuit's decision in Steinberg. There's another case that I want to make sure doesn't...
Well, I'm sorry, I was going to ask, because you said, okay, well, the narrow way to do it is prohibiting profanity and personal attacks.
Yeah.
So, okay, we're going to assume we can define profanity. Maybe we can consult the old George Carlin routine. That's for the older people here. But there's new words. I don't know. We'll have to update it. Okay, so personal attacks. So what if the banner, again, had her picture and said that she's corrupt and incompetent and should be fired? I mean, that's a personal attack. But it has a profanity in it. So what do we do with that?
Your Honor, I think the way that the Fourth Circuit in Steinberg talks about personal attacks is it's an attack against someone that doesn't have any connection to the subject at issue in the meeting. So, if the individual that you're attacking is at issue in the meeting for some reason, their qualification, for example, are at issue in the meeting.
But during the public comment period at this particular, isn't if one of the council members is corrupt and incompetent, isn't that always relevant to anything they're doing?
No, I agree. And as I said earlier, I think that criticizing government officials is at the core of what the First Amendment protects. And I think my argument is going to be strongest when you can consider all three of these factors together at the same time: the personal attack, the profanity, and the act of unfurling a banner. I don't think that saying an individual is corrupt is necessarily a personal attack in the way that Steinberg, the Fourth Circuit decision that I'm mentioning, defines personal attack. I think personal attack is something that is completely irrelevant to the topics that are being discussed. And if you're talking about a public comment period where there's free discussion, it seems difficult to imagine a city being able to, a local government being able to enforce a rule that says that an individual could not make comments to that effect. So as I said, I think my argument is going to be the strongest when you can consider all three of these key factors together as opposed to considering them separately. I do think that there could be difficult line-drawing questions about what constitutes profanity and what constitutes a personal attack. I think on the facts here, I don't think there can be any real dispute that profanity was used and that this banner was a personal attack against an individual who wasn't at issue for purposes of the meeting. I'm happy to take any further questions on the First Amendment issue if it would be helpful. Otherwise, I can turn to resistance. I'll make just two brief points on the resisting arrest argument. I understand my friend on the other side to mainly contend that this defendant had a right to resist arrest because the arrest was awful. And as we've been discussing this morning, I think that the arrest was awful because it was consistent with the First Amendment to prohibit an individual from unfurling a banner in the middle of a public meeting with profanity on it and with a personal attack on it. So I think that those two arguments sort of go hand in hand. The second main argument that I understand my friend to be making is there's just not substantial evidence in the record of resistance, and I would point the court for this point to State's Exhibit 8, that roughly between the 11-minute 4-second mark and 14-minute 15-second mark, where there's body cam footage that shows very clearly the defendant preventing the officers from putting handcuffs on him, struggling, pulling away from the officers, and I think that that conduct is more than sufficient for a rational jury to conclude that the defendant was resisting arrest in violation of the statute. Unless there are further questions on the resistance point, we would respectfully request that the court affirm. Thank you.
Thank you, Your
12
Honors.
minutes.
And try to get through this in an organized fashion. So I think, as the state said, their case relies on whether or not this was a limited public forum. And beyond the reasons I mentioned earlier as to why this is a designated public forum, Steinberg actually doesn't help the state's case as far as whether or not this was a limited public forum. In Steinberg, the court noted that there, the board expressly limited discussion for that one meeting to one topic and one topic only. And that gets to the point of what the government needs to do when it's establishing a forum and whether it's considered a designated public forum, which isn't restricted to topics, and a limited public forum, which can be restricted to speakers, which restrict speakers, or the topics that they can discuss. So a meeting where the government has said, we're only talking about this and nothing else, it's not even sort of, to my reading of Steinberg, sort of a normal board meeting for this board. We're talking about this one thing. So restricting topics to nothing but something here is different than in this case where you can talk about anything as long as you're not profane or vulgar or use personal attacks. That makes this meeting in Avery County a designated public forum where content-based restrictions are subject to strict scrutiny. However, even if this court decides this was a limited public forum, the state's reference to personal attacks and profanity show that those restrictions are in fact viewpoint restrictions, which are not okay in any form. The fact that the rules prohibit personal attacks, but again, the same logic I was using in narrow tailoring, but leaves out personal praise, shows that the board has a disagreement with negative opinions of someone, but at the very least says nothing to expressing positive opinions about someone.
So, counsel, if we take the content out of it to address the state's argument, address the issue of the unfurling of the flag and it being held up and that being potentially the eye of the board as being disruptive to the board. Address that.
Cohen says pretty plainly that even with someone who's wearing a jacket that says F the draft in the halls of the court, those who are offended, especially government officials who, as Judge Stroud noted, we expect people to come in and say offensive things. But if it catches their eye and they're offended, they can simply avert their eyes. That is sort of the standard that we're setting here under the First Amendment, that people are going to come in and say things or even just display things that you might not like. But if you're so offended, you can just avert your eyes, so long as they're not engaged in other conduct that actually disrupts the meeting. And on this point, Hicks said that he heard the unfurling, but he also said that he could hear everything that was going on in the board meeting, and then he didn't know that there was really anything amiss until Watson approached Mr. Barthel. I think that's more like your example of, I'm here sort of getting my things ready. No one knows, if you watch the video, no one sitting in the public area of a meeting looks back at what that is. Only the board members can see what's going on, and Watson. So it's not a limited public forum. Steinberg doesn't help. And if you look actually in Cornelius, on page 803, Cornelius cites Madison Joint School District for the proposition that a meeting just like this is a designated public forum, where it was a school board meeting that was created by statute as an open meeting, the same scenario that we have here. Judge Stroud, to your point as to how far the government can go in a limited public forum, I would take issue with my friend's contention that no limited public forum, that the government could not restrict a shirt or a hat that had some sort of political, whatever kind of message it had on it, because under the precedent, in a limited public forum, content restrictions are okay, as long as they're not viewpoint-based. So as long as the government says, I disagree with that message or with that opinion, then say, no hats, no shirts with any kind of messages on them. So they can go that far, and it doesn't matter that a shirt or banner. I think, along the lines of, this was profanity, or why do we find that? In a designated public forum, content restrictions are subject to strict scrutiny. The Constitution doesn't care. We're not going to restrict things because they're, quote, profane, because, as I was explaining to Judge Gore, we don't have objective tools to do that. The government doesn't have objective tools to do that. Your Honors, there are no more questions. I'll just conclude briefly. Here, the board meeting was unlimited forum. Watson restricted Mr. Barthel's message because of the content and because of Mr. Barthel's viewpoint. Watson violated Mr. Barthel's free speech rights by restricting his speech, and the state compounded that violation by prosecuting him in this case. Because Watson violated Mr. Barthel's right to free speech in the first instance, he had right to proportionally resist. Accordingly, Mr. Barthel respectfully requests this court reverse the judgments. Thank you.
Let me ask you just, did you just say that you can have a rule that says no banners as long as it's content neutral?
In a limited form, not in a designated form.
So in a designated public forum, which is what you said, is you can't have a rule that says no banners.
In a designated public forum, this would be getting into intermediate scrutiny and a time placement restriction. I think a rule that says no banners whatsoever, there's an argument that that's not narrowly tailored, and it doesn't necessarily get to the board's substantial interest in maintaining decorum without referencing banners and flags in some disruptive conduct. But simply unfurling a banner is not a disruptive conduct, in my opinion. Thank you.
Thank you for your argument. Take it under advisement. Go ahead.
All rise. This session of the North Carolina Court of Appeals is adjourned.
I realized once we got the calendar, started looking at everything, reading the root through it. Neither one of us, it really hit the nail on the head.
Yeah.
Forum, and which was like, first thing we should.
There was a short little screen problem where we'll necessarily our internal recording work. So if anyone wants to read a little bit placing that.
Okay.
It's only the first 2 minutes. Just let them fuck us start.
There may be a few nerds concerned. With it.
Yeah.
Thank you. All right, well, take care.
Yeah.
Good to meet you.
Yeah, sounds good.